And this may be the last time we have Judge Grierson before us in Senate Judiciary. And I want to extend my appreciation on behalf of the committee for all you've done and wish you nothing but the best in your retirement. We hope that you won't be a frequent visitor to the courts, that you'll be able to go out, do what you want to do, and enjoy life. And
that means stay out of trouble, Judge Grierson.
Right. But our real appreciation, Judge, you've been terrific. Whenever we've called on you, we may not have always liked your answers, but you've always been there. So
thank you very much, Senator. And appearing in the courts is one thing, and who knows, maybe I'll wander into the halls of the State House again. So we'll see.
Well,
also on behalf of Eric, would want to maybe say something on myself. On behalf of Judicial Retention, the Judicial Retention Committee, thank you so much for so much help through the years and steering some people through some difficult situations that turned out okay. So thank you very much.
Well, thank you again, Senator. It's needless to say, it's been quite an experience, quite a transition. Working with the legislature, I can remember my first day before a committee, and it's been a learning experience right along. But it's been good, and I appreciate the comments, and I certainly enjoyed. Maybe enjoy isn't the right word, but I appreciated my time before this committee, and I know we didn't always agree, but we certainly were able to work through a lot of issues.
I think it's very appropriate that perhaps your final comments to this committee will be on the Raise the Age bill, which you were, as I remember, you played some kind of reggae to
well,
shake them up or something of that nature.
I remember being in the committee room towards the end of the session when this bill had gone through, and I know how hard you had worked on the bill throughout the years, Senator. And somewhere earlier in that meeting, you had indicated that you liked reggae music and Bob Marley in particular. And so towards the end of the session, that hearing, I said, well, I think Bob Marley has a song that would be appropriate then. That you were relating how much things had changed from the old Hanlon's Savage cases. And so you had pulled out your phone looking for a Bob Marley song, and I pulled out my phone a little bit quicker than you, but I think together we played Marley's Stir It Up.
Stir It Up. And that's certainly what we did.
And I don't, I would dare say that probably rare when the sounds of Bob Marley were coming out of the Senate Judiciary hearing room. But,
I missed that one.
Yeah, well, that was quite the.
It was good.
It was good. And so we're here talking about Raise the Age specifically and problems that have been encountered. The administration has talked about a pause and about corrections that may be necessary to the law. And I think the committee's amenable to perhaps a short pause plus changes that are necessary. Now that we've got almost a year under our belt, unfortunately, the implementation year was during the middle of a pandemic, which has impacted everybody. So, any comments from the judiciary on Raise the Age? Any problems encountered by judges? Anything you have to be appreciated?
Thank you, Senator, and thank the committee for inviting me here today. For the record, Brian Grierson, Chief Superior Judge. In anticipation of this meeting, this hearing, I did reach out to judges who have been sitting in the juvenile docket for the past year to try to get their perspective. And I would tell you that uniformly, the judges that responded to me were positive about the raise the age, the experience with raising the age to 18. I say positive in one sense, and that is, I think there was a certain amount of trepidation as to what this was really going to do as far as impacting the court and the caseloads. Obviously, we all know that pre-pandemic, particularly the juvenile docket was experiencing increased filings, primarily as a result of or to a great extent as a result of the opiate epidemic. And so we were already facing high caseloads and we were concerned. But that concern from the judges I heard from did not appear. The caseload from this perspective was manageable, and they, I think, again, those that responded to me put it in a very positive light. Even they did express, I'm not going to say concerns about age 19, but in recognizing that is the next step, they felt comfortable with the process as it related to 18-year-olds, and they thought it was they were positive experience. And obviously the whole issue of do we put it on pause or do we move ahead? And I understand that that's, as it always has been, a policy decision on the part of this committee, where the court judiciary generally does not weigh in on policy decisions, but we have been supportive of the concept, certainly from the beginning. It may be a good time to pause, and I say that only for reasons probably different than some other witnesses. As you know, the pandemic and this application of law came about right in the middle of the pandemic, and we were at that time operating on limited hearing schedules, predominantly remote hearings, and we continue to use remote hearings as much as we can, particularly in the juvenile docket, for reasons unrelated to this particular legislation. But because of the impact of the pandemic, and it's fair to say that it created a further backlog, it may be for those reasons, from a purely operational standpoint, a good time to pause this. And I can't guarantee you that we'll catch up in the next year, but I think it's been a good experience. And I don't see where a pause would hurt. Having said all of that, from a positive standpoint, I think the concerns that the judges expressed to me are what you've heard from other witnesses before me today. I was actually trying to monitor this hearing as well as another one that I was participating in, so I can't say that I heard all of the testimony. But some of the issues that came up, the difficult cases of with youth who, quite frankly, need a more secure setting than we have available in Vermont, was the concern of those judges. There's not a lot of those cases, at least as they reported to me. But when one of those cases presents itself where we're looking for a more secure setting for youth, we just don't have that. And that becomes a difficult issue for the court to come to grips with, is where can we place this child? Where are the resources that this youth needs? And so that's, I think if there was a concern, it would be what you've probably heard from other witnesses on those cases that are out of the ordinary and require additional resources that the judges, I think, struggle to be able to identify. And in short, I think that's the assessment of the judges sitting in that docket.
Do you think that has to do as much with the closure of Woodside as it does the pandemic and limiting? I know, down at the program I used to operate, 204 Depot, they are short-staffed and haven't been able to keep up with the numbers that they normally have there. They've also had other issues, but short-staffed, and I think that's true in many of the programs. So
I think it's clearly a combination of the two. Without having that option of Woodside means we've got to look elsewhere, and that's where the struggle begins, not only for the court, but for the state's attorneys, the defense attorneys, and DCF involved in these cases. And I know everyone struggles with that when those difficult cases come along. And the COVID conditions have impacted the court operations. There have been some positives, though, as a result of that. As I indicated, we're doing more by remote hearings. And quite frankly, for some of the families impacted by juvenile proceedings, whether it's chins or juvenile justice, we found in some situations, in some dockets, the participation of litigants has actually increased because they can connect remotely, whereas they may not have the transportation, or perhaps they don't have the childcare that allows them to leave and appear in court. So it doesn't, in some cases, it's been a real benefit to that process.
Yeah, I know of situations where it's been actually easier for families to visit remotely. Now, for example, if the child is from Newport, the child is placed in Bennington, it's a heck of a ride weekly to try to visit their child. So, they've mixed in with the remote visits. It's actually given more visitation than they would otherwise have, probably even once a month if you're lucky. I guess I'm not asking you for a solution to the secure setting, but if the child is 18, could they still be placed in a correctional facility? Should we consider, someplace that's separate, sight, sound, etc.?
I think you've just identified the issues, as I understand it. Placement in a setting, in an adult correctional center requires those restrictions, and I think we struggle to be able to accomplish that. I think for a while, the Rutland facility, the Marble Valley facility, may have had placement available. I'm not sure that they still do.
I think they had 4 beds
Right.
at one time.
Right.
Senator White.
Judge Grierson, does it have to be site secure, or can it be staff secure?
Senator, I'm not 100% sure on that, on the requirements. I thought it was site and staff
Okay.
secure. That was my understanding, but there may be other witnesses that can be more
Okay,
firm in that. But that was my understanding.
thanks.
Well, Woodside's gone now. It's been plowed under, so that's just. And, I don't know what's going on with Beckett.
Yeah, of course, with Beckett, they have to be under 18.
Right, so it doesn't solve that
So
problem.
it does not solve the problem. And
18 or 19-year-olds.
right. And when I first heard about the option of Beckett, I thought it was going to, people talk about it in terms of being a replacement for Woodside, but it's not really. It's a different type of facility. And so that presents the problem. And then I know at least one of the witnesses this morning, and some judges have referred to the Sununu Center, and that sometimes becomes the.
You actually have to have a hearing just to
Yes.
determine whether.
Yes, because they're going out of state. Yes.
Other questions for Judge Grierson? All right. Thank you, Judge.
Thank you again for the committee. Thank you, Senator.
Thank you.
Good luck.
Thank you.
Thank you very much.
Thank you, Senator Nick.
Our next witness is Attorney General Thomas J. Donovan. Some people call him TJ.
Good afternoon,
Welcome.
Senator.
Welcome, Mr. Attorney General.
Thanks for having me. And let me add my best wishes to Judge Grierson on his next adventure. Judge, I don't know if you're still on, but always enjoyed working with you, and I wish you the best.
Well, thanks, TJ. Obviously, we started together up in Chittenden, and so it's been a good long ride. So
Well,
thank you.
Looking forward to staying in touch.
We will. Thanks.
Thank you.
We'd appreciate any thoughts you have on raise the age, youthful offender, or problems
Sure.
you've seen and where your office is at.
For the record, TJ Donovan, Vermont Attorney General. Thank you for allowing me to testify this afternoon. I support raise the age. I think it's sound public policy. It's in the interest of public safety. It's in the interest of justice. I think there's a direct correlation to the hearing that many of us were at last week in terms of the expungement bill. By keeping kids in family court, obviously you don't have that public criminal record. I think the science, the brain science about brain development would indicate that keeping kids in family court for the goal of rehabilitation is the right decision. And again, that sound public policy. I think you have protections built in with, if it's a serious case, I understand that the law allows the state's attorney to petition the court to remove the case to adult criminal court. And I think overall, this is a net benefit for not only the young people who may find themselves in family court, but for our community. And, as Judge Grierson just talked about, I think you're going to have those limited cases, which are going to be difficult. I certainly understand that, but I don't think those are going to be a small percentage of the cases, in my opinion, based on my experience as state's attorney. And I don't think those cases should prevent others, the vast majority of people, from getting the benefit of this very good legislation. And I think the court, I think the prosecutors, I think the defense attorneys have that unique ability to find creative solutions in those difficult cases. And I think they're few. I think the number is small. That's my experience. It's anecdotal. I can't point to the stat, but Senator Sears, you talked about Woodside. I mean, there wasn't many folks in Woodside towards the end. I think the push has obviously been not to go to secure settings. And again, we're talking about those exceptions, those small number of cases. And I trust the court and the lawyers to come up with creative solutions as when the facts require them. But overall, this is a good law. This is going to benefit our community. It's going to benefit the young people by getting them the help they need, but not going to saddle them with a criminal record. And we know the issue of the criminal record, so I support it. Forgive me, I don't know how long, when people have talked about a pause, how long that pause is.
We don't either.
Yeah, so I just worry. We know this. We can always find a reason not to do something, and this is going to help a lot of young people, and that's why I support it. I don't think it should be delayed.
Thank you. It seems to me, based on your testimony and that of others, there are a small number of individuals who are, for lack of a better term, problems. We don't have placements available for them. We don't have this, we have concerns about public safety if we try to treat them in the community. But then we have, I think Senator White used the figure 95%, I don't know, it may be higher, of the kids who are benefiting from this and not creating a public safety issue. How do we, that's the conundrum. If we say to 19-year-olds, you got to wait another year or another 2 years or whatever the pause is that fair to that 95% who won't get into serious difficulty that will be stuck in the criminal justice system? Because they pause it. I mean, that's a dilemma that I'm struggling with right now. Is there some way to change the law to protect, the Commissioner of Children and Families talked about wanting to have risk assessments be the guide. I'm not sure we want to leave that to administrative function, but any thoughts on how to deal with that small minority of really troubled kids who are dangerous and present a danger to public safety?
Yeah, I mean, my quick thought is, I mean, I acknowledge the dilemma, and I acknowledge there are going to be those cases. I do think they are. It's going to be a limited number of cases. I want to be very clear about that. But I think the law addresses it. I would agree with you, Senator, about I'm not sure the risk assessment would be the right tool. But let's talk the public safety issue. If the charge comes in, the law allows the state's attorney to remove the case to adult criminal court, 16 and above. I think that's an important piece to this because that goes to the public safety issue. And public safety is going to come first. But the vast majority of these kids, and they are kids, should get the benefit of being in family court, not going to criminal court and coming out with not only that arrest record that's public, but likely a criminal record. The issues with all the work we've done, frankly, that this committee, Senator, has done, has addressed those unintended consequences of putting young people into the criminal system. And so I don't have an answer I don't think anybody has the answer about what do we do with this very small number of cases that may remain in family court. But I am willing to work with the stakeholders to find those solutions. But I think we're talking a handful of cases just based on the numbers of Woodside. And the vast majority should receive the benefit without delay of going to family court. You talked about the Sununu placement and the other placement, and I'm not generally a fan of the out-of-state placement, but that may be an option in some of these cases that we have to consider because the benefit to the greater good, in my mind, is so clear here.
Thank you. Other questions for the Attorney General? TJ, thanks so much for taking time out of your busy schedule.
Thanks for having me. And I know you're not wearing the colors today, Senator, but go Sox.
Go Sox, absolutely. It's too cold to put my Red Sox shirt on, and I didn't want to put a sweatshirt on. I thought Senator Benning might be here, and I didn't want to offend him.
Well, good to see everybody, and have a nice weekend.
You too. Thank you.
Bye-bye.
Our next witness is an old friend who hasn't been with us for quite a while, is on to different things within the ACLU, but his name is Jay Diaz, and he worked closely with us on a number of initiatives a few years back. Jay, nice to see you again.
Nice to see you as well. It's great to be here with you all again, and I'm happy to talk to you all about this. I'll add to the chorus that has, given bon voyage to Judge Grierson. It'll be tough to see him go, but I wish him best. And I want to thank Attorney General Donovan for his comments here and for participating in this hearing. I think he was spot on.
What is the you were made comments in the press, that's why you're here, about raise the age, and you were concerned about a pause. You were concerned about I'm sure you're representing the ACLU, so I asked you to, what are some of your comments on this?
Sure thing. Yeah, so again, Jay Diaz, General Counsel for ACLU Vermont. I think a lot of my comments will be echoes of what others have said. I understand that DCF and DPS want to initiate this pause. I guess I'm still having a little trouble understanding the why, because it seems to me that that the number of cases is not going up, or not going up substantially, according to the data that Judge Grierson provided. It seems to be juvenile cases seem to be going down, I believe. And then the other issue is what is the real difference between someone who's 18 and someone who's 19? So is it a caseload issue? Is it about that DCF needs more staffing? What is the actual need that they are talking about? And so until we understand that, we can't understand how long any kind of pause should be. I think a bunch of people so far seem to say that it's reasonable, and it may be, but if we're going to do any kind of pause on raise the age, it needs to be well-reasoned, evidence-based, and it needs to come with a clear expectation and a clear timeline of what needs to happen and when it needs to happen by. Because I think without any kind of clear timeline, that's just a recipe for failure and further delays. The other piece I'll add is, I've heard some of the comments around the small minority that presents a public safety risk. These are kids in the juvenile system that present a public safety risk. And I think, as Attorney General Donovan said, if there is a crime that presents such a risk, or that is such a bad crime, obviously they can be charged as adults in criminal court. So you don't have to go to family court first for that. And then on the other hand, the sense I'm getting is that this is DCF and DPS kind of, it's just their feeling. It's a prediction that they have about the potential dangerousness. And I think that that's something we need to be careful about, because there's all types of ways that our one's own bias can come into place in seeing someone as dangerous. Because what we know about young people and why we enacted this statute, why we worked so hard to get this through and took it so seriously, is because we looked at the science and we looked at the data, and what it told us is that, as you all know, young people are still developing, and if we can reach them at this time, there's a very good chance that they can change. They are malleable. They can change very quickly with the right supports. So I think it is more about finding the right supports than claiming that there are some few who we just can't reach. And regardless, of course, those small number of cases shouldn't dictate the entire policy, as Senator White and others have said.
That's interesting way to put it. I think you're saying that if there is a pause, it should be done in a way that has clear timelines for when we will accomplish the implementation. And I think the best guide on implementation is the Department of Children and Families' own implementation report of 2019. Yes.
So Jay just put a little thought in my head, and I think it would be good for us to hear from the administration exactly why it is, what they need to see, why they're asking for this delay. I mean, the only thing we heard was that there are these horrible cases out there. I would like to know why it is that they want a delay and what they plan to do in the meantime to justify that delay. I don't know if they are willing to do that or not, but it does seem to me that just asking for a delay without a good rationale and without saying what's going to happen between the time that it was to be implemented and the new time, what's going to happen in there to change it? Or they'll ask for another delay.
But I agree with you to the extent that there has been, due to the pandemic, and difficulty in establishing long-term programs that could house these kids in a secure environment if it's needed for public safety, but also it's not clear to me that in the cases cited by the governor in the veto message of 107 and in the cases cited by the safety, whether or not it already is covered under the law that allows them to take a 16-year-old to 17. And I need, if I get this wrong, Eric, correct me, but I believe that the law would allow them to transfer cases to adult court where they're particularly dangerous through a motion of the state's attorney. So
That's correct, Senator Sears.
That kid from, I don't even know where they were from, but if a kid from Holyoke, Mass comes to Vermont, trafficking drugs, guns, whatever, and is deemed to be extremely dangerous and is part of a gang or whatever, that is still available.
Yeah.
Am I correct? But if the kid was under 18, there's no place to put him or her. That's my understanding. That's the dilemma, unless they use some. Anyway,
So-
Jay, we're taking away from your.
No, this is, I mean, I think it sounds like you're all circling on this question of like, so what do we do with this small number that may present challenges when we don't have a placement for them? You know what, I don't know if this will get me in trouble or not, but you know, just one thought I had, I know when people with developmental disabilities commit a crime, you know, our state has done a good job trying not to send them to the prison system, but has a separate process under which they can be put in a placement with, you know, one-on-one care, basically, usually in a remote setting, and, you know, and be monitored and be cared for and monitored and kind of taken care of that way. You know, it's a small number of people, and we're able to do this because of that, probably because of some other funding sources. I imagine through, through the federal government for disability services. I'm not sure on that, but it might be a model for how this could work if it's really necessary. I'm not sure that it is, but at least it's a different way to go about doing this that doesn't involve, you know, locking someone up in a secure setting. The last piece I'll mention, you know, there's been also talk about the YO status, and, you know, I'm not involved in the details. I don't, you know, I'm not doing criminal defense cases, obviously, so I'm not in the weeds on this one. But it's worth noting that as we work with Raise the Age and YO, you know, 18 generally has always been, it's always kind of been it's an arbitrary age, right? It was just kind of picked out of a hat at some point in our history. And obviously it started with, I think, selective service, and then with voting. But, you know, I'm not totally sure on the history of where it comes from. And I think the brain science would tell us maybe things are a little more malleable than that. So it's just something to consider as we try to really make determinations about different ages and who's going to be included. And yeah, and again, I just mentioned that area of concern I have around some of the comments regarding from Commissioner Sherling, just, trying to make these kinds of like predictions about kids and what they will or will not do. I think we strive through this statute to give them the benefit of the doubt. And still under YO, if they violate any of their conditions, that they can come back in and be put into criminal proceedings and be sentenced. So I think it's, there are backstops already in the law for a lot of these scenarios.
Mhm. I agree. I think that some of the problem is that State Attorney Marthich pointed out is what's available in, say, Chittenden County may not be available in Bennington or Windham County. What's available in Bennington and Windham County may not be available in Grand Isle or Orleans County. So that we have this real geographic justice problem that we've tried to correct, but I think that's part of the issue is what the services aren't, the same everywhere. So that may also be part of it. Senator White.
So I guess I would, we know that is true, and we know it's true for adults and everything else in the justice system. But I guess my question would be, is the administration proposing that they would actually get those services during this pause time? They would get those services in all those areas so that they would be treated equally. I mean, I kind of doubt that, but I think that's a problem with all of our justice system. It isn't just this, and so there is not equal justice for adults also across the state, and that's no reason, I think, to delay this.
Well, anything else, Jay, that you'd like to comment on? I think you raised, actually, you put it in a way that I think we do need to have the answers from the administration. What is the pause timeline, and what is it that could be accomplished while we provide that pause and have the law go into effect? One thing that I keep hammering at constituents who try to argue with me about the law is that the outcomes for the age group under 22, actually it's under 25, but the under 22, they're horrible outcomes in terms of recidivism. And so in terms of public safety, if you can change that dynamic, you've actually improved public safety. And we also know that in terms of racial disparities, there are huge differences for young people that end up in the system. I think it tries to address both of those concerns. It's interesting you mentioned the 18-year-old and how it became magic, because when I grew up, it was 21. Couldn't vote till you were 21. You couldn't do all kinds of things until you couldn't drink. Still can't drink. Some states you could drink at 18, other states was 21. And then came Vietnam, and you could go to war at 18, but you couldn't vote. And I think that was where a huge change took place to become the 18.
It is an interesting history, and just worth keeping in mind. I do want to note, I don't know that it's been mentioned today, but And I tried to talk about it with some of the media outlets I spoke to about this, but this program is a success story. This is a great success, and I think we should not lose sight of how successful it has been. We may not see it. These cases are confidential, obviously, but keeping more kids out, we know that it does have a positive impact, as the Attorney General said. And I think by and large, what you hear from Judge Grierson, what you heard from the state's attorneys is that by and large, this is going well. And I think we should just remember that. So I appreciate you, bringing that up, Senator Sears.
Thank you. Any further questions for Jay? Jay, thanks for taking time out of your busy schedule.
Thank you all. Thank you all for focusing on this. And I'll see you soon.
Well, I hope so. Our final witness is Jennifer Pullman, the recently appointed Executive Director of the Center for Crime Victim Services. And if I get that wrong, let me know. But Jen, welcome back. We've seen you in many other capacities over the years in Senate Judiciary, and welcome as now the Director.
Thank you. It is great to see you all in this capacity. Just winding up my third week here, and do want to mention it's kind of interesting that I'm starting this role discussing these issues, because my very first thing that I did in a policy manner back when I worked for Crime Victim Services about 18 years ago was to sit down with Senator Sears to have a conversation about thinking through basic rights that we could be affording victims in delinquency cases. So starting a new role and talking about similar issues. This will be the last time you'll hear my spiel about the center, because I expect I'll see you all pretty often in the coming session. But as you know, the center is the state mandated agency that both oversees the delivery of victim services in Vermont, establishes and maintains the victim assistance program that provides the funding for the 27 victim advocates in the state's offices, also the victims compensation program and the restitution unit. And we also serve as the pass-through for all state dollars and federal dollars that go to victim services programs, which allow us to provide support for 69 different victim services programs in our state. And I'm grateful for the time to speak with you today. I am not here actually to debate the merits of where the age should fall. And I think if you had 10 victim advocates in a room, they might all fall in a different way. What I'm here to spend my time with is to talk about what 100 victim advocates would all agree that does need a look. And I think that Raise the Age has actually elevated the discussion and the inquiry, and is going to allow us to talk and think through more deliberately what role do victims have in this process, whether it's delinquency, youthful offender, or Raise the Age. I think that Evan, when he spoke earlier, talked about sort of the piecemeal approach to when we've been looking at addressing young people who are in the system through acts that they have committed. And I think that the piecemeal has created, and you've heard some of that today from practitioners, an inconsistency, confusion. And I think the thought that we can use this time to consolidate what we have, simplify it, not only makes it easier for practitioners, but also makes it easier for victims, because the confusion is real. And just as with almost everything in the state, it varies by county, it varies by judge, it varies by state's attorney. And our laws do evidence that there's a lack of consistency. So again, as we've thought about these reforms and how they've been enacted, we're thinking about this as an opportunity to also think about looking at victims' rights. And we don't see that we've had a chance to keep pace with some of those efforts. The rehabilitation of individuals, young people, their ability to be successful later on in life is certainly incredibly important. But we'd also like to focus some time, though, in terms of the discussion moving forward about the other part of the equation, which is that victims also need support and need support in terms of putting them on a path to success as well. I do want to say I completely understand some of what State's Attorney Marthage has spoken about, wherein there is this perception that a delinquency case allows somebody to get off easy, and that sometimes what we ask of young people in a delinquency case is actually way more challenging than what the criminal justice process might ask of them. And I say that because before I moved to Vermont I worked in Boston representing children in abuse and neglect and delinquency matters. And I probably represented easily over 200 juveniles in delinquency cases. And I would, as their attorney, come up with these great plans for how we were going to keep them out of lockup. And I'd talk about maybe some counseling and different support services that they could utilize. And pretty frequently I would hear from them, I'm done. I don't feel like the probation officer. I just want to go to lockup, get it over with, and I'm done. And that was heartbreaking to me that was a viable choice for them in their lives. So I absolutely do think that a robust juvenile response in terms of supporting our young people can ask more of them than another system might. But then the question becomes, do victims actually, would they prefer the criminal justice process? And I think for multiple reasons, perhaps, but I think there's one important reason why that is the case, because victims' rights in criminal cases are significantly different than what they are afforded in delinquency and YO cases. And for many victims, just the feeling that they've been heard and that they have information, that they know that something's being done, that they know that they are safe, that's a real critical piece. So when we think about, do victims want, what do they want out of the process? The ability to feel heard and the ability to have basic information that they can utilize to make sure that they're making safe decisions for themselves. I do want to touch on a few, very few, because we're thinking through this in a more deliberate way, but I do want to touch upon a few areas where the inconsistency is pretty significant and clarification is needed. And also the level of rights might arguably be, or we're arguing, is insufficient if we're thinking about more cases going down the road of a delinquency process. And we're talking about older individuals. So I'm, again, not speaking about what that age should be. I just would like to highlight some areas where we've heard from advocates and we've heard from victims that there is such a dramatic piece or an unclear piece. One of those is information regarding basic information during the investigation period before there's actually been a charge filed. We understand in an adult case, that's really clear. Law enforcement is directed to provide information up front. But when it's unclear as the road that it's going to go, we can have some pretty serious matters. One advocate was sharing a crime that involved sexual assault, wherein the investigation took a while and the victim had no clue who the person was, even though law enforcement did. So that's information that is dramatically different just in terms of how the case is treated. And I did want to flag that. Also from a victim's perspective, we can see in some of the delinquency or the statutes that speak to a young person's act, that victims are directed to, that it's unlawful for them to speak to anybody about any aspect of the proceedings. And unlawful means that in some cases, that's a victim's been told you can be charged with a crime if you share this with anyone. That from a victim's perspective is scary and it's isolating and it's dramatically different. So I just want to, again, think through that piece. There's inconsistencies as far as when a victim can learn the identity of the individual, or if they ever can. There's inconsistencies around if they can learn about discharge from probation or conditions of probation. And again, I'm speaking with the YO statutes and delinquency statutes and some of the pieces relative to raise the age. And conditions of release, some provisions speak to the fact that a victim can learn when there's a condition of release that impacts their safety, but in some cases that's silent. Finally, I do want to speak to the piece about public safety in 5284 and in the discussion around what does that look like, how is that interpreted? And I think, again, there's an inconsistency that I think could be helpful to think about, because you all made it's very clear under 5288 that victims in YO proceedings have certain rights. One of them is to be asked for input at the motion hearing for a juvenile to be considered for WIO status. So that's very clear in 5288, but what we're hearing from many advocates across the state is that some courts, some state's attorneys don't see that as a right. And I'm wondering if when we look at 5284, and there's a reference to public safety, but there's absolutely no mention during that entire process about inquiry to the victim or victim safety, if that might be a piece that we could clarify and tighten up in order to either have a cross-reference or just make that more specific. But I'm certainly interested in inquiry that it sounds like this committee is proposing in terms of looking at exactly what's involved in that. I thought that the term Evan used as far as the procedural ping pong was excellent. And I think that, again, just being mindful of the fact that that delay it does impact the victim. But again, when we're talking about victims' rights, it's, again, what does a victim get to know now that it's in the criminal court versus then it gets bounced back to juvenile, then it goes back and forth. So again, that has a very real impact. Finally, I do appreciate what the Defender General said this morning about getting a time to get the resources in place. Certainly COVID set us back a tremendous amount and we're not where we thought we would be. But I do think that it's going to take a little bit of time to build capacity. I certainly appreciate what members of this committee have said and what some witnesses have said. There's always reasons not to do something. And I think that making space for something to happen, but really being very clear about what the time frame is for that. Because I do see that there is a training issue. The Defender General spoke to that as well. It is important, I think, to do an inventory about what exists. I do think that thinking about placements for a lot of our young people that we've been talking about. And I do think that we would love an opportunity to, again, we plan to submit a more specific proposal. There are many victim services providers who've been working on these issues. And so we also will be submitting, as for the state's attorneys, a more specific proposal. But I think that we need to do more training around what the system, what is in place, and really in terms of we're thinking about our role as far as how we can support courts and practitioners in understanding what victims' rights actually are, and then also in terms of helping parties who are working more and more with victims. I'm thinking about DCF, not that DCF probation officers and other individuals, other programs that are coming in contact with crime victims. So just some more support around that. So I think that is about our piece. I do think that there's a rationale for delay in terms of giving a little bit more time for some of this stuff to get up to speed. But I do understand and appreciate, again, what the committee members have voiced as far as how long do you do that? How long do you allow that to exist? So building in some capacity. And I was a little bit concerned today when I was hearing about psychosexual evaluations and how that piece is rolled out. And I think that would be helpful to have some time to explore what we are doing in some of those cases. So we will be submitting something in the future. To be more specific, today my thought was to just ask the committees or use the committee's time to just flag some issues and to be grateful that we are at a place where we're, I think, in a better position to address some of these issues in a larger way and move everyone forward, and everyone who's doing the work getting the tools and the knowledge and the consistency that they need to make sure that we're doing right by the state and by the people that we serve.
I was going to talk about this at 2:30, but since you raised it, I'll raise it now. And that is, my goal is for November 8th to have information from various individuals, including yourself, the victim. I don't mean individual, organizations and individuals, so that we have your suggestions as well as state attorneys, anything anybody else has, and that we try to put together legislation that can be ready for debate the first week in January and get a bill out quickly. And that's my goal, because I think this is a particularly important issue to give plenty of time for people to know what's going to happen. Because if we wait the normal process, let's say we do pause for a year with clear timelines and all, I'd much rather have people know we're pausing in January than pausing in mid-May when the new effective date is July 1 of 2022. So you're cutting it awfully close if we don't treat this as kind of a timeline, because obviously DCF should be preparing if they're going to end up being stuck with doing it on 27. If 19-year-olds are coming in on 7/1/22, they need more than 6 weeks to plan for that. So I would hope that everybody gets together. The committee starts hashing out what the legislation would look like on the 8th, and that Eric and whomever else starts. I assume I already started drafting, but certainly I appreciate both you and Jay have clearly stated the need for a reasonable timeline that has clear expectations for what's going to be accomplished during that timeline if we do delay.
And I can assure you that we will be ready for the 8th. People, it's a matter of just pulling it together in a cohesive fashion for all of you. And I certainly appreciate you all are in the second year of a biennium and you have timelines that you're dealing with. And so to have everything ready to go beginning of January is absolutely doable. And we're grateful for the opportunity to do that.
Thank you. Any other questions or comments for Jen? Welcome back to Senate Judiciary.
It's good to be back. Feels like coming home.
Yeah. Committee, I think we've had some discussion. I know Senator White is going to leave in about 10 minutes. So are there any particular things, committee, that you'd like to see at our next meeting, issues that you need fleshed out that Eric can get administration on, or whomever else is witnesses?
I would like to see them say why it is that we need to delay, what they think a delay might add, what their plans are for what they're going to do during that delay to actually be able to implement it in a better manner.
And if I could tack on to that, at a certain level, we've been talking about resources, and it would be good, we keep referencing the shortages in various places. Has the administration put together a tally for how much would be necessary? And then we could work that into the timeline of when that money would get to them and how long it would take them to use it.
Yep.
I guess also certainly estimates of what some of the recommendations would cost, maybe various levels of different kinds of recommendations and what they would cost would be certainly helpful. Do they have, has someone researched what are the programs that work in other states that address this kind of issue? I mean, what is working?
I don't know. We're the kind of the guinea pigs.
We're kind of out in the front, right? Right.
Yeah, I think it's the first state in the country that did it, right?
Yeah.
Well, if we look, there are two different kinds of resources. I think that there's the resources for those, that 95%, that are there the resources necessary to or available for them to go to family court and be treated that way? And then are there the resources for those few people who really need some other level of care or supervision? I think that there's two different kinds of levels of resources here that they need to address. And just before I run, I'm going to throw this out. This isn't directly related to this, but because we're talking about 18-year-olds, and when Jay was talking about 18 being kind of the magic age, The Vermont Bar Association has put out a really good pamphlet it's called something like I'm 18 and now what are my rights, or something like that. The Bar Association put it together, and it talks about all the rights and responsibilities and duties that fall to someone when they turn 18. We give it to residents here, and I give it to anybody who has a kid who's turning 18. It's really well done. So, and Terry Corsones will send you any of them if you want them.
Yeah, it'd be helpful.
Peggy, maybe Peggy could see if Terry Corsones could send those out to each of us.
Yeah, of course, was going to do that.
Thanks, Senator White, for that. But I go back to the implementation plan that DCF did with Columbia Justice Lab. And it seems to me that what is it? I think the question really is, what is it going to take for them to be able to implement the law? And what would they change in the implementation plan now that they've had a year under their belts? It sounds like some of the things are there in the law that cover some of the concerns of the administration.
Yeah, I don't quite get why they are concerned about, except for the secure placement for those kids. I don't understand why they're concerned about not being able to deal with those few people in the appropriate way, because it seems to me it's all there in the law. So.
Okay. Eric, anything you want to add?
No, I don't think so. I think I got a good understanding of sort of the course that the committee's taking so planning on the 8th, maybe to I don't know if I'd call it a markup, because we won't have but at least sort of a committee discussion about putting together the thoughts for what's going to be in the.
From here, yeah.
Right.
Yep.
I'll send an email, Senator Sears, maybe an email to DCF and DOC today with the questions that have come up, to ask them to prepare to address those on Monday. Does that make sense?
Yep. Yeah. Maybe Peggy, for the next meeting, if as documents, you could repost the implementation plan.
Yep.
On our committee page, and perhaps, Eric, you did an excellent job on your 18 pages of the law.
Thanks.
No, and perhaps repost that on the committee page so people are aware to reference to that, because I had forgotten that we put in provisions for non-Big 12.
Right.
So are you on the 8th? Do people like Erica know that they also should have their, because she said they were going to have some very specific recommendations.
Yeah,
so they should have them to you before that.
Yeah, I think they've already started. The state's attorneys have already begun work on theirs.
Oh, okay.
I believe.
Do you mean for Monday's meeting, you want those posted?
Yes.
Okay.
It's you've already got them somewhere.
Yep, I'll find them. Was it are they documents that we just did the last couple of weeks or last session?
I believe we had the implementation plan posted when Lael Chester spoke from the Justice.
Yep, I remember that. Yep, okay. And Eric, you'll let me know which one specifically he is talking about, or is it?
Yeah.
No, actually, what I'm talking about is what Eric's thing that's posted today on our.
Oh, okay.
I'm just adding that again to next Monday, so people can refer to it on Monday.
Got it.
What Eric did was put little comments like takeaway, Big 12 offenses against children, youth age 14 to 21 must start in criminal division unless SA files my own petition, family division.
Yep.
I'm not sure people remembered that.
Yeah, look for the red italics for the comments.
Yeah, I think that was really helpful to me.
Mhm.
Okay, is there anything else? All right, I guess